Good afternoon, everyone. I'm Wendy Kavanaugh, President of GSAE. Thanks for joining us to learn more about both the CARES Act and legal strategies for association meetings. As you may know, pivoting to virtual is new for a lot of our associations. As we move through the program today, I'll provide a bit of commentary for how we're using Zoom to bring you and our members relevant information. A couple of reminders: everyone except our speaker will be muted. And for the best experience, you may want to toggle your viewing options at the top right of your screen between gallery and speaker view. Please use the chat feature to register your questions. And we are recording today and will send all of you follow-up information after the program as well. Our speaker, Jeff Tenenbaum, is one of the nation's leading association attorneys. He's an accomplished author, lecturer, and commentator on association legal matters. He counsels his clients on a broad array of legal issues affecting trade and professional associations, as well as other nonprofit organizations. He regularly represents clients before Congress, federal and state regulatory agencies, and in connection with governmental and internal investigations, enforcement actions, litigation, and in dealing with media. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and he is one of only 5 lawyers in the U.S. Legal 500 Not-for-Profit Hall of Fame. He's also the author of the ASAE published Association Tax Compliance Guide. Welcome, Jeff, and I am going to turn my scene off now. Thanks so much again for joining us today.
Time for your questions, and I know there's going to be a ton, and I will do my best to try to answer as many as I can, but I apologize in advance for kind of the compressed time period and the amount of material. I did send to Wendy and Wendy and her various colleagues from the various SAEs, I believe, have forwarded to all of you some resources of mine that has a lot more detail than I'm going to be able to impart to you guys on the webinar today. For the first part, there's an article that I just updated this week with all kind of new developments and additional details about the Federal CARES Act and the resources that are available to associations and nonprofits. And it's written with an eye toward associations specifically. It looks like Wendy just posted those in the chat. That article, which is on our website, and there's a link to it, has a ton of detail about everything I'll be talking about. The first half of this webinar is not going to have a PowerPoint presentation, but I encourage you to look at that article for more details. The second part of the presentation about meeting and event cancellation issues, there's also a very comprehensive article. ASAE published it a few weeks ago, and I've made further updates to that. And then I do have a fairly comprehensive PowerPoint that we'll be using for the second part. But all of those links will be sent to you so you can access those materials. So with that being said, for the first part of this, we're going to talk about what sort of economic assistance is available to associations and other nonprofits in connection with the current pandemic, and particularly what sort of help from Congress is available to associations and other nonprofits. So as many of you have probably heard, there's this new federal law called the CARES Act, which was enacted, I don't know, about 2 weeks ago, a $2.2 trillion bill that provides economic relief for individuals, small businesses, hospitals, state and local governments, and nonprofit organizations, among others, with various forms of financial relief for the economic injury that has been imposed on these organizations and individuals because of the pandemic. I'm going to talk about a few highlights of the programs in the CARES Act, talk about some of the kind of eligibility requirements, some of the features, some of the benefits of these programs, and then I'll open it up for questions for you guys. So the kind of the feature aspect of the CARES Act, kind of the premier program that a lot of folks have been talking about, I'm sure you've been reading about it and hearing about it, is something called the Paycheck Protection Program. It's a brand new program, never existed before. It's administered through the U.S. Small Business Administration, although the U.S. Treasury Department has quite a significant hand in helping to set the rules and helping to administer it as well. It's essentially a jointly administered program. And the idea behind the program is to provide assistance to small employers defined as under 500 employees. So whether you're a for-profit business or a nonprofit that qualifies, either way, you have to have under 500 employees. And the idea is that if you have under 500 employees, and if you keep your employees on the payroll for the next couple months, so basically if you've suffered economic harm, you apply for this special Paycheck Protection Program loan, and then you use the loan to cover primarily your payroll costs for the next couple months, and that loan will be forgiven. So it's a very popular program because it's a forgivable loan if you use it for primarily your payroll costs. The problem for many associations is that it's not available to 501c6 tax-exempt organizations. It is available to some nonprofits, but they have to be classified as tax-exempt under Section 501c3, or there's a certain category for certain veterans organizations called 501c19. But unless you are exempt under C3 or C19, you do not qualify for the Paycheck Protection Program. You also probably heard that that program, which was initially funded at, I think, $249 billion, ran out of money after the first few days. That is true. The Senate passed a bill, not yesterday, but Tuesday, to provide an additional $310 billion of funding for the Paycheck Protection Program. The House is taking that up today and is expected to approve it. I expect the president will sign that tonight. And so hopefully kind of the spigot will be turned back on for funding for this program starting tomorrow. But of course, the problem is that unless you're a 501c6 organization, and not only a 501c6 organization, a 501c3 organization, but not just a C3 that has employees. So a lot of you are probably thinking, I've gotten this question from tons of people, well, our primary association is a 501c6, but we have a 501c3 related foundation. Can that entity qualify? And the problem is that because that entity has no employees, it's basically not going to qualify. Only the entity that, even if the C3 reimburses the C6 for the value of staff time and whatnot that's utilized by the C3, unless the C3 has its own employees, it's not going to qualify under the Paycheck Protection Program. So essentially 501c6 organizations were kind of left out of the mix. It was very much a political decision. Based on, in hindsight, it looks like a lot of bad information that a lot of folks on the Senate side had when the first CARES bill worked its way through. As many of you probably have heard, and I've been involved in this effort as well, ASAE and others have taken the lead on making folks on the Hill and lobbying the Hill to try to expand the Paycheck Protection Program to include 501c6 organizations. Unfortunately, the new supplemental funding bill that's about to be approved does not make any changes in terms of nonprofit eligibility. It does not expand the scope of who's eligible for the Paycheck Protection Program. That being said, there is very high awareness right now amongst many key people on the Hill about the need and the importance to expand I'll call it the PPP, the Paycheck Protection Program, to 501c6 organizations. But the earliest that will likely happen, if it happens, and I think there's a good chance for it, is when Congress passes what some people are calling kind of CARES 2, kind of the second big economic stimulus package. Likely not, for at least a month, if not longer, at the earliest, unfortunately. But that is the situation, and it is really unfortunate because the PPP is a very valuable program. I'm not going to go through all of the details of it. You can see all the details in the article that Wendy sent out to you guys. It would be helpful if it's expanded. A lot of people are saying even if it is, it's going to come, unfortunately, later on. But we will have to keep a close eye on, and hopefully the program will be expanded to include 501c6 organizations. I saw some questions pop up about, if we have a for-profit subsidiary, or of course a related foundation, or we have, say, an association management company that has the employees. The key is who has the employees. So if the C6 has the employees, it's not going to qualify. If you work with an association management company and the AMC is the one that has the employees, if the AMC itself has less than 500 employees, it can qualify for a PPP loan, but not the associations that it manages. Similarly, if you happen to have a for-profit sub, and the for-profit sub is the one that has the employees on the payroll, which would be an odd construct. But if it had less than 500 employees, it theoretically could qualify. But that is what it is. By the way, I see a question about why didn't ASAE also advocate for C5s or C4s. ASAE would love for the PPP to be expanded to all tax-exempt organizations. Right now, the message that's come down from the Hill is that if there is going to be a good chance of getting a limited expansion to 501c6 organizations, the politics of including C5s and C4s, because of the C5s are the unions and C4s tend to be the political organizations, technically social welfare, but a lot of them are highly engaged in political activity. It complicates the politics very much, and that's the reason why ASAE has limited its advocacy to 501c6 organizations. Now, I should say there is another loan program available under the CARES Act. It's a longstanding SBA, Small Business Administration program called the Economic Injury Disaster Loan Program. Typically only available to small businesses, for-profit small businesses. That has been expanded, though, to allow all tax-exempt organizations to be able to qualify for it. 501c6 can qualify, 501c6s can qualify as well. A few important limitations, though, which kind of really, I think, diminish the value of the program, unfortunately. That program, by the way, also ran out of money. The new bill that's about to be approved by the House today will provide an additional $60 billion in funding for this program, so that spigot should be turned back on. However, this program only works, well, let me take a step back. So there's two parts to the EIDL program. First, there's a forgivable loan portion of it. So the first $10,000 that you can borrow under this program, if you're suffering economically from the pandemic, and you can demonstrate that, then you can get a $10,000 loan that is forgivable. It's called an EIDL advance loan. It is forgivable. However, the way that SBA is administering it, they're only going to give you $1,000 per employee that you have. So for smaller associations that may not have that many employees, you're going to be maxed out at $1,000 per employee. And then overall, they're putting a max of $25,000 per EIDL loan, period, to try to make the money go around further. So in short, there's not a lot of money available in this program. Up to $10,000, again, $1,000 per employee is forgivable. The rest has to be paid back. It is a fairly good interest rate, 2.75% with a 30-year repayment term. But again, effective maximum, even though theoretically you can get loans up to $2 million pursuant to the statute, the max that they are essentially imposing is $25,000 per loan. So again, limited utility, but it is an opportunity for C6 organizations. And if later the PPP program is expanded to include 501c6 organizations, then you can apply and qualify for both loans. Right now, the way the law is written is that you cannot use the loan proceeds from EIDL and PPP for the same expenses, because you have to prove what expenses you're spending it on. But you can theoretically apply for both. And I saw someone asked who administers the EIDL program. Also administered by the Small Business Administration, and this is an important distinction. The PPP program, for those of you that are C3s that have employees and can apply for that once the funding gets turned back on, you apply through your private lender, through your bank, your credit union, et cetera, any other SBA-approved lender. Whereas for the EIDL loans, including the EIDL advance loans, it's a direct application through the SBA website. And in my article, there's a link to that application page. So it's a direct loan from the Small Business Administration. One other, and by the way, yeah, someone's asking, it's for the advance loan, it's maximum of $1,000 per employee. So if you had 10 or more employees, you can qualify for the maximum $10,000. If you only have 5 employees, then you can only qualify for $5,000, but 10, so if you have 25 employees, the max you can qualify for is $10,000. That's for the advanced portion of it, the portion that is forgivable. For the rest of it, up to $25,000 max, it's not based on the number of employees. And for these EIDL loans, you don't actually apply for a specific amount. You put in all your financial data, and then SBA determines what you are eligible for. And then, of course, like all the PPP loans in this, you go through this application process, but then you're not actually bound to the loan and obligated to the loan until you actually agree and sign the loan documents at the end. One other important feature of the CARES Act that I want to highlight is called the Employee Retention Payroll Tax Credit. For those of you who are on the ASAE Congressional Town Hall that I moderated last week, we had some discussion about this because one of our speakers, one of the members of Congress, was one of the principal authors of this, and she talked about it quite a bit. It's essentially, so even though you're tax-exempt organizations, and with the exception of unrelated business income tax, you don't pay tax on your income. You don't pay corporate income tax on your net income. You do pay payroll taxes for the on employee wages. Social Security and Medicare taxes, there's an employee portion, 7.5% of compensation, and then there's the employer portion that employers pay, which is 7.5%. That employer portion is subject to this, and someone asked what the name of it again. It's called the Employee Retention Payroll Tax Credit. And again, the idea here is that if you retain your employee, if you have a drop in revenues, and again, my article gets into all the details, so I'm not going to get into the nuances here, but essentially, if you can show you have a significant drop in revenue compared to last year, and if you retain your employees, then you can get a payroll tax credit up to 50% of the qualified wages of those employees. It's up to a maximum of a $5,000 tax credit per employee for the balance of this year. So again, not a huge amount, but if you have multiple employees, it all adds up. And it is a refundable tax credit as well. So if the credit exceeds the amount of the payroll taxes, you can actually get this money back. You don't have to apply for it. It's what's called a self-administered program. You just deal with it like you deal any other aspects of your payroll taxes. But it is something that is in place for the balance of this year. It's done on a quarter-by-quarter basis, and it's something I encourage you to look at. One qualifying factor is that if you received a PPP loan, you are not eligible to take advantage of this tax credit. But if you did not apply for or are not eligible for a PPP loan, you can take advantage of the tax credit. And you can also take advantage of the tax credit if you have an EIDL loan. They are not mutually exclusive. So why don't I stop there and see what kind of questions we have. I see there's been a ton that have come in. Those are kind of the highlights of what I wanted to talk about with the CARES Act and these programs. There's obviously a lot of details. There's a lot of nuances. There's a lot of questions that my colleague and I have been advising our clients on in terms of, how these things apply. By the way, Wendy, it looks like the resources, those links that I sent you, they're 3 separate links, and I think because they're all together in one post, they're all kind of bleeding together. So you might want to post those separately so people can easily access them. All right. If C6 has a for-profit sub and the sub has all of the employees, the for-profit could apply. Correct, assuming it has, this is a PPP loan, presumably you're talking about. And yes, if the for-profit is where the employees are housed, if it's essentially functioning like a PEO, a professional employer organization, then yes, the for-profit sub could apply on its own. Do 1099 employees count for the C3 organizations? Again, presuming for the PPP program. Well, first off, if you have someone who's a 1099 worker, they can't be an employee. Those terms are mutually exclusive. They're either an employee or they're an independent contractor. If they're an employee, they get a W-2 form at the end of the year. If they're an independent contractor, they get a 1099 IRS tax form. And no, 1099 workers, independent contractors do not count for this purpose. That being said, independent contractors are eligible for PPP loans in their own right, like other small businesses. And there's some guidance that's been put out by Treasury and the Small Business Administration that says that even sole practitioners, sole proprietors, which is a tax status, are eligible for PPP loans as well. And there's some guidance as to how to qualify for that. Some of these questions I've already answered. Advice for a C6 organization who mistakenly applied for a PPP loan program and were approved. Yeah, we've heard this. I've heard a number of stories about this, and not just C6s. There's a number of folks who have applied for PPP loans that should not have qualified, but did qualify. Needless to say, there's a lot of administrative challenges in all of these programs. We have seen that happen. You should not accept those funds. The question is, should we refuse the loan funds and send them back to the bank? Yes, you should, because in the end, you're going to be forced to repay it anyway. And you sign these loan documents under penalties of perjury. Not a good idea to keep the monies if you're not eligible for them. Again, you can refuse them, return them, and then if you want, apply for an EIDL loan. If we are part of a professional employee organization, a PEO, can we qualify for the employee retention payroll tax credit? Yes, the PEO where the employees are held, the one that pays the payroll taxes, would be eligible to take advantage of that payroll tax credit. And yes, it is self-administered. If you take the PPP loan, are you not eligible to take an EIDL loan? No, you can, say you're a C3 that has employees, you can actually apply for both. The CARES Act makes that clear, but you can't use the proceeds for the same expenses. So like for the PPP, you have to show, you have to be able to show, you don't actually show it to the Small Business Administration, but if you ever got audited, you have to be able to show that you used the funds, 75% of the funds for payroll costs, which are compensation and employee benefits, including health insurance. And then the rest of the 25% or less can be used for essentially utilities and rent or mortgage interest payments. That's it. And if you do it that way, you use at least 75% for the payroll costs, and then the other 25% or less for those other specific things I mentioned, then the loan is forgivable. So you have to apply it to specific expenses. You cannot take an EIDL loan and apply it to the same expenses, but EIDL loans have a broader set of things that they can basically spend on anything that is suffering economically because of the pandemic. So it's a much broader, and again, it's not a forgivable loan except the first $10,000, but it's a much broader kind of bucket of things that you can spend the money on. Okay, Wendy, why don't you queue up the PowerPoint for the second portion of this? And by the way, I apologize. I know that was a lot of material, a lot of detail to go through without having a PowerPoint to focus on. My apologies. I literally haven't had a chance to put a PowerPoint together on those issues. But on these issues now that we're going to get into the second portion of this, which are, believe it or not, a lot more complicated and a lot more nuanced, I do have a very robust PowerPoint that I hope you guys will find helpful. And so let's move into this. And again, there's a lot of material to cover. There's also a lot of strategy involved in successful execution of a lot of the things that I'm going to be telling you here. So there's a lot of nuance. I will do my best during the presentation to get into that. But feel free to pose whatever kind of questions, and I'll try to leave as much time at the end to deal with those questions. So Wendy, did you give me control of?
You need
PowerPoint?
to, yes, you have it now. Thanks.
Okay. There we go. All right, how do we get this to full screen?
I'll start it for you again. There you go.
Okay, sorry. So here's what I want to try to cover today. Let me move my video down. Okay, so the focus of what I'm going to talk about here today is on association meetings and other events with a specific focus on the contracts, contractual provisions. I don't know what's going on here. On contractual provisions and the effect or ability that those provisions have in your ability to cancel or postpone your meetings without having to pay penalties. That's kind of the real focus of today's program. As you all know, this pandemic has just wreaked havoc on in-person meetings of associations. All sorts of meetings are being canceled, postponed, rescheduled. And as you also probably know, most event contracts, when I say event contracts or meeting contracts, I'm talking about the contracts you have with hotels, convention centers, and other venues, and sometimes for larger meetings, vendors as well, AV companies, other folks like that. Most of those contracts say that if you cancel the contract, particularly after you get past a certain point in time closer to the meeting, then if you cancel without a legal excuse to cancel, then you're going to be stuck with paying very significant cancellation penalties. 6 figures, 7 figures, very, very large potential cancellation penalties. Obviously varies contract by contract, meeting by meeting. But if certain things are satisfied, certain requirements are satisfied, and that's what I'm going to talk mainly about today, then you are able to cancel those contracts without paying any penalties. Now, granted, it's not going to make up for your lost profits that you would have earned, but it will avoid you having to pay significant cancellation penalties. That's what we're primarily going to focus on today. These provisions that I'm referring to are called force majeure provisions. You've probably all heard the term. You've probably heard it a lot recently. That's going to be the focus of what we're going to be talking about here today. And then I think the most helpful and interesting part of the discussion is going to be the various kind of strategies and options that my colleague and I literally spend every day, all day long, advising associations on how to deal with these issues, how to try to navigate, this very difficult path of trying to be able to kind of pull the trigger on a penalty-free force majeure cancellation without having to pay penalties to the event venues. It's a really tricky thing to do, and I'm going to try to walk you through the key considerations. And then there is something called event cancellation insurance that I'll talk briefly about at the end. Okay. Wendy, I'm not sure what's going on here, but okay, so it's the next slide. Force majeure. So what is force majeure? So force majeure is actually, technically it's a French term. It's a French term that essentially means you have some intervening event that makes it impossible for you to hold the meeting. In a lot of contracts, this is referred to as an impossibility clause, if it's not referred to as a force majeure clause. Some contracts refer to it as termination without cause. But it is a provision that exists in most, looks like maybe there's a slide missing here, that exists in most meeting contracts. It says if a force majeure event happens, if it's a triggering event that's detailed in your force majeure provision, and if that triggering event has a certain effect on either party's ability to perform under the contract, then that force majeure clause can be exercised by either party, and either party can terminate the contract without paying any penalties. And so if you can think of it like this, there's kind of two aspects to, if you look at the bottom bullet point here, there's kind of two-part test for every force majeure, for most force majeure provisions, I should say. There are some, it's a rarity, but there are some that kind of only have the first part. They don't have the second part, which is much more favorable for the event sponsor. But essentially how this works is A, do you have a qualifying event, act of God, war, strikes, riots, disease, or something else that's a triggering event? And then second, what does the effect of that event have on either party's ability to perform under the contract? So the two key things to focus on here, and actually let me go to the next slide so I can kind of, oh, I see the slides were out of order for some reason. This is a kind of a model force majeure provision. So I want to focus on this so you can kind of see exactly what I'm talking about. So the top part of this slide kind of has a whole list of potentially qualifying events. But then what it says is, or other similar cause beyond the control of the parties. A lot of force majeure provisions are written alternatively to say, including but not limited to. And so ideally, because disease is often not referenced specifically, or something like disease, pandemic, epidemic is often not referenced in these contract provisions, you want to look to see if there is kind of a catch-all clause, like, or other similar cause, including but not limited to. That's really important, because then that means you have a triggering event when we're talking about this particular pandemic. But then the second part is, if you look here, and I obviously bolded and put this in italics for everyone's benefit, it wouldn't typically be in bold and italics in a contract provision. making it inadvisable, illegal, impossible, or commercially impractical to hold the event. Now, this is, when I say model force majeure provision, this is model from the association's perspective. Because if you look at the bookended words, inadvisable or commercially impractical, those are key words because what they do is they make it a lot easier for the association to establish that, yes, this pandemic is making it inadvisable or commercially impractical for us to hold our event. Unfortunately, of the hundreds of force majeure provisions that we've reviewed in the last 6 weeks or so, I'd say 85% of them or more only have the illegal or impossible portion of that contract provision, which is a much narrower, much higher bar to establish, basically saying the pandemic is making it illegal or impossible for us to hold the event. And I'll talk in a few minutes more about what that means and how that kind of plays out. So, as you might expect, hotels, convention centers, and venues are generally going to favor and push for language that's more narrow, impossible, or illegal, whereas the meeting sponsors, the event planners are generally going to look and push, like I've always pushed for years, broader language, frankly, either commercially impractical or inadvisable or something similar. Anything like that will work, but a much broader standard that makes it easier to argue that the pandemic is having that effect. Now, if the contract, and this is again a rarity, but I have seen a few in the past few weeks, if the contract does not contain a force majeure provision, then you have a strong argument that some of these, what are called common law contract doctrines, there's a doctrine of impracticability, a doctrine of impossibility, and a doctrine of frustration of purpose. Those are the three most relevant ones. Those are pretty good, helpful, broad doctrines from the association's perspective that basically says if there's an unexpected intervening event, the parties' agreement assumed that such an event would not occur, like it wasn't a foreseeable event, and the unexpected event made the contractual performance impossible or impractical, then those doctrines of impracticability or impossibility will apply. Now, the doctrines, it's common law, so it's state-based. The doctrines vary state by state. Some states have more favorable jurisdictional precedent than others, but it is something to be aware of. Unfortunately, if your contract has a force majeure provision, the way that most hotels and convention centers interpret it, they say, look, the parties agreed to this particular language, therefore these common law doctrines don't apply, they don't come into play. It doesn't mean they're right in that analysis, it just makes it more difficult for the association to assert. Now, let's get into some of the strategy here. If your force majeure provision has the, let's assume it has some kind of catch-all phrase, including but not limited to, so this pandemic will be covered. But let's say it only has the impossible or illegal standard. Frankly, even if it has more broad language like commercially impractical or inadvisable, it's largely the same basic analysis, which is you have this provision that's in place. That provision doesn't change, but what changes is how does that provision get applied to the facts that exist at the time that you might terminate? And that's, by the way, how the attorneys for the hotels and convention centers view this. They say whenever you cancel, whenever you pull the trigger and send that written cancellation notice, that locks in the facts as of that date. So whatever situation exists as of that date, that's how they're going to analyze it, not what might happen tomorrow or the week after or the month after. They're going to look at what conditions exist at that particular point in time. Now, again, just because a hotel or convention center is taking a different view on this doesn't mean in the end they would prevail if this got litigated or arbitrated. But most of the hotels and convention centers are taking the position that they are not going to accept a force majeure cancellation without penalty unless there is a governmental ban in place that prevents your meeting from occurring at that particular date or dates in that particular location. So as you all know, we have a lot of state and local bans on large gatherings, and we have a lot of state and local stay-at-home orders, which are in place right now across the country. Most of them have expiration dates. Even those that don't have expiration dates, you can't just presume it's going to go on forever. And what we're starting to see now, yesterday in Georgia, and we're going to see it in other places where some of these bans on large gatherings and or stay-at-home orders. And by the way, they're generally in most states 2 separate things. So you have to look at both separately and independently. A lot of them have different expiration dates as well. What you have to look at is, okay, we have our meeting coming up. Let's say you had a meeting coming up a month from now. What are we, April 20, whatever we are, late April 23rd. If you have a meeting coming up, say May 23rd, and there's a ban on large gatherings of, over 150 people in that particular city that's in place through the end of May, or I think in DC, for instance, we have one in place through June 11th. If you can show that that ban is in place in that city through your meeting dates or through the beginning of your meeting dates, no question you can pull off a successful force majeure cancellation without any penalty. Unfortunately, most associations can't wait that long to pull the trigger. They're under I'm not telling you guys anything you don't know. You're under enormous pressure to cancel your meetings that are coming up in June, July, even August. Hopefully not. I know some of you guys on the phone have meetings coming up in August that we all hope don't get canceled, but there's a risk of that occurring, and everyone's worried about that. And in some associations more than others, there's enormous pressure to cancel those meetings. But the problem is that none of these governmental bans extend that far, and at the federal level there are no bans. There's only advisories from the White House and the CDC, no actual bans. There are some international travel bans, but there's no domestic bans on travel or large gatherings, just advisories. And even those have, like the CDC's guidance, has expiration dates. And so what we're finding is that it's becoming more difficult to argue for a successful force majeure cancellation. The way that I view it is you have this window, this kind of theoretical window of a beginning point. It's not set in stone, but some date, and once that initial date passes, you're probably in that zone where you can more likely than not successfully argue for force majeure cancellation. Maybe that zone starts now, maybe it starts, and I'll talk a little bit more about the strategy there, but then at some point that window is going to close. And largely what we're talking about is whenever the state and local bans get definitively loosened enough or lifted such that the meeting could be held. And we're starting to get to that point now. At least there's a lot of concern that folks were getting to that point in some geographic locations, likely not in New York or California, but in a number of other places. Right before this, had a call with an association that has a big conference scheduled for Vegas for this summer. And, as we saw yesterday, some comments from the Las Vegas mayor, there's a probably better than not chance that things get very much loosened up from a governmental kind of regulatory perspective sooner rather than later. And so that window is going to likely close in places like that, which means if you want to try to pull off a force majeure penalty-free cancellation, you're probably going to have to do it sooner rather than later. Because what you're trying to show is that for the vast majority of these clauses that say impossible or illegal, you're trying to show, look, we can't wait until the day before a conference to cancel. That's not reasonable. But at some point, we're going to say, look, because we can't wait that much longer, at this stage, 30 days out, 60 days out, maybe even arguably 90 days out, it is impossible for us to move ahead with this, and it's impossible for us to have the meeting because of all the pre-planning and prep and everything that needs to be done. So therefore, we are going to argue that this force majeure provision applies now because we're close enough. These bans may or may not be extended, but we're close enough that we want to successfully argue that. What we're seeing in terms of how it actually plays out and how the hotels and convention centers are responding, a few things. A, if you're in a state or a city that has some pretty strongly enforced bans in place, we're finding that the hotels and convention centers are being more accommodating when it comes to allowing force majeure cancellation. Secondly, you got to look at the language of the force majeure provision itself. If you have broader language like commercially impractical or inadvisable, we're finding the hotels and convention centers are accepting force majeure cancellation more frequently. And then thirdly, and this is probably the most important factor, is timing. It's all about timing. And I have counseled quite a number of associations in the last 6 weeks to wait as long as you can. The closer you get to your meeting dates, the stronger your case is going to be for force majeure cancellation. Now you're balancing a lot of competing considerations, right? You get enormous pressure from your members. I've had clients tell me we're losing all kinds of credibility because we're not canceling our June meeting. And look, I've told almost everyone, you got a meeting in May and in June, an in-person meeting, we all know you're not going to have that meeting. It's not going to happen. It's not a question of whether you're going to have the meeting. It's a question of when you're going to cancel and how you're going to be able to pull the trigger on such cancellation so that you can minimize the risk of any cancellation penalties. So it's not whether, it's when, and the timing is absolutely critical. Now, I'm sure we're going to get a lot of questions about this. In terms of this impossibility standard, another thing that we're focused on is, in addition to the governmental bans making it impossible or illegal to hold a meeting, which is what the hotels and convention centers are really focused on, I believe there's a very strong argument that if your members or if your attendees are coming from employers or other institutions where they are prohibited from traveling during your meeting dates. We're seeing this a lot in healthcare. We're seeing it a lot in the higher ed kind of college and university setting. A lot of colleges and universities have imposed travel bans on non-essential travel through the end of the year, shut down professional development travel and expenses and things like that. If you're we have some clients where the attendees are primarily coming from overseas, or at least a large percentage, where they're prohibited from traveling here, either by our government or by the foreign governments or both. If you're in those kind of situations and you can prove that through polling, through other things, I think that's a very strong argument to argue impossibility, that it's impossible for you to hold the meeting. Now, granted, the hotels, convention centers may push back, but I think it's very strong. It's a very strong argument to use. And when you ultimately pull the trigger on a force majeure cancellation, it's really important what your letter says. So these force majeure provisions always require the cancellation to be in writing. And we're not talking about a one-sentence email that says we're canceling pursuant to this provision. No. It's the opposite. It's a letter where you're throwing the whole kitchen sink of all of the legal and factual arguments why it's illegal, impossible, commercially impractical, whatever your force majeure provision says. You tie it into that, you cite that provision, and then you give all the evidence as to why it's illegal or impossible. The state and local governmental bans, CDC guidance, comments from the White House. We had one yesterday where the state health commissioner made a comment at a press conference about how, I forget it was he or she, thought that in that particular state, that it would be unsafe, to have any in-person meetings through the end of the summer or something like that. That's very relevant, okay? It's not a governmental ban, but the senior health official in the state, public health official, making a comment like that, it's very relevant. You want to gather all of that relevant evidence, lay it out in the order of your strongest arguments to the weakest, and put the whole kitchen sink in those cancellation notices. Those notices go typically to the attorneys for the properties, and they're going to evaluate each one differently based on all these different factors. They very much know about all the governmental bans that are in place, when they're supposed to expire and whatnot. But the more you can strengthen your arguments, the better your case is going to be. Now, let's move on to this next slide. I'm kind of jumping all around, but I'm really trying to focus on the key things here. Timing is key, as I just said. Generally, the longer you can wait, again, recognizing there is going to be an end to that theoretical window, that you don't want to let it get to that point. But the closer you can get to the meeting date, and what we're finding is that if you're within a 60-day window from the date of your meeting, associations seem to have a lot more success in successfully arguing force majeure. Now, every property is different. We're seeing enormous pushback from the hotels and convention centers, in fact, more this week than in the prior weeks, I think because of the dynamics we're seeing on the national level, in terms of what's coming out of the White House and whatnot, and some of these states and cities starting to open their geographic locations back up. We're starting to see we saw a lot of really hard pushback in the beginning. And I think for the intervening few weeks, there was a lot more accommodation by the hotels and convention centers. Now we're starting to see a tightening up and pushing back on things. But if you can get within, I think, a 60-day window, ideally a 30-day window, but that's not realistic for most associations. If you can get within a 60-day window, wait until the 60-day mark before the first day of your conference, I think your odds go up significantly. Now, what's another strategy that you can utilize if either, say, your meeting is in August, you just do not want to have this meeting. Your members are telling you, we're not going to come. Wait, we can't do that. Or September. And I see a comment here about September. I'm getting the same thing for October. There's a lot of associations that say we are not going to have an in-person meeting this year, period. And we know we want to cancel, but it's going to be very hard to argue impossible or illegal based on governmental bans, for a September or October or even August conference when it's so far out, we just don't know what the case is going to be. The other strategy that has worked well for many associations, including many of our clients, is to negotiate with the property to either postpone your meeting to later this year or to cancel the meeting, but rebook a new meeting, whether it's the same meeting that you're rebooking for next year, the year after that. I got one yesterday that we rebooked for 2027, and it was a whole town, like a smaller city, but it was working with the CVB because it was a convention center and multiple hotels. Couldn't rebook their annual meeting until 2027, but it worked and got all the cancellation penalties dropped. But if you can book one or more new meetings, it could be a different meeting, it could be a smaller one, a combination of smaller meetings. But if you can book future meetings with a hotel or convention center, what we're finding is that they are so desperate to get meetings on the books that they are more willing to waive or significantly reduce your cancellation penalties. In the beginning, they were only partially reducing cancellation penalties, like about 25%. More recently, we're seeing much broader kind of complete waivers of cancellation penalties if you're willing to rebook. An important thing, though, to keep in mind, if you're talking about postponement, say to the fall, say you have a summer meeting you want to postpone to the fall, and they're willing to waive the cancellation penalties if you postpone, the thing you have to recognize is that you are going to have significantly reduced attendance at that meeting. It's just, everyone recognizes it. I'm not telling you anything you don't know. It's going to happen. And so most contracts with hotels and convention centers, especially the hotels, have what are called attrition clauses. And these are clauses that impose, this is when you go ahead with a meeting, but you have less than expected attendance. There are generally attrition penalties for sleeping room revenue and food and beverage revenue, essentially guaranteed minimums. Usually have an opportunity to adjust those minimums downward up to a certain point in time. And then after that, you're locked in. And if you don't meet those minimums, these are written all different ways and some are more complex than others. But bottom line is if you don't meet those revenues, then you're hit with these attrition penalties, basically to help the hotel or convention center make up the shortfall in the sleeping room revenue and the food and beverage revenue. It's critically important that if you're going to postpone your meeting to later this year, or even arguably for the early part of next year, recognizing you're going to have reduced attendance, you need to reduce those guaranteed minimums and or eliminate the attrition penalties or reduce the penalties or some combination of all of that so that you don't get stuck with big attrition penalties when you have 50% reduced attendance from what you would otherwise expect. So that's pretty much what I just talked about here. If you're going to postpone, here's what you need to do to reduce your risk. There's also the last bullet point here, talks about if you do end up holding your meeting and we're still in a situation where there's no vaccine for the virus, what sort of things do you need to do to help protect your association from liability and protect your attendees from physical harm? That's a kind of a webinar for, I think, a future day. Finally, real briefly, event cancellation insurance. Right now, if you go to try to purchase event cancellation insurance for future events, you cannot get any coverage for what are called communicable diseases. No matter what you pay extra, you cannot purchase coverage right now for communicable diseases. But if you purchased coverage last year for an event that's occurring this year, or I have a few clients that actually purchased it 2 or 3 years ago, you can purchase it that far out. If you paid extra to have communicable diseases covered by the policy, then arguably you do have coverage for any cancellations or postponements or reduced attendance that occur for your meetings this year. It's a lot more complicated than I'm laying out, and the nuances of how to make sure you get coverage are something that, again, I spent a lot of time on, too much for today's program. I wanted to flag that for you. You should always look, because if you have event cancellation coverage, not only covers losses, things like cancellation penalties, but it also covers your lost profits that you would have earned if you had the event. You guys, you have or will have access to all of these PowerPoint slides. A little bit here about commercial general liability insurance. When you do go ahead with your meetings, if someone contracts the virus at a meeting and files a claim. And then same thing on the employee side in terms of workers' compensation insurance. You can take a look at that. And then finally, this is some kind of best practices for negotiating your future meeting contracts. We are working with a ton of associations right now in connection with their future meeting contracts, both just the normal cycle of entering into new contracts, future meetings, as well as rescheduling existing meetings and now entering into new contracts or amendments to those contracts. Not unexpectedly, there is a significant focus on the force majeure clause. It's no surprise to anyone. It's becoming very hotly contested, heavily negotiated. I've seen some new, I just earlier today saw kind of the Fairmont's new kind of corporate kind of force majeure clause, which is, frankly, really not much worse, than what we've seen in the past. But bottom line, it's going to be heavily negotiated. And one suggestion I have here, if possible, this rarely happens, but one thing I've always tried to do is tie the force majeure clause into the attrition clause, so that if there's a triggering force majeure event and the force majeure clause applies, but you don't want to cancel, you decide to go ahead with the meeting anyway, you want to be able to use that to reduce or eliminate your attrition penalties. And then finally, even though you can no longer get coverage right now, at least, it may change in the future, and there may be some congressional involvement in this, like there was after 9/11 in terms of terrorism insurance. But event cancellation insurance is still something valuable. Trust me, the associations that have coverage right now for their canceled events this year are absolutely thrilled that it was, the best $5,000 or $10,000 they ever spent. Even though you can't get communicable disease coverage, it does cover many other unexpected events, and it's something still worth looking into. That is it. I'm going to stop now and open it up for questions. So we got a lot. Yes, so the CARES are probably a common question. Our meeting is in November, our meeting's in December. We're thinking about canceling, and we're worried about proceeding. This is one where it's almost impossible to successfully pull off a force majeure termination now for a meeting in November. It's almost impossible. I could theoretically come up with a set of facts where you could argue impossibility, but it's going to be extremely difficult. Really, if you've just decided, your board's decided, whatever, that you cannot go ahead with a November meeting and you're not willing to wait, then your best bet is to try to negotiate with a venue, try to get them to waive the cancellation penalties. If you book a new meeting for next year, the year after that, multiple meetings, give them some incentive. If you have to, pay some cancellation penalties, but try not to pay all of them. I've given advice to some clients to maybe, instead of paying cancellation penalties, offer to up the food and beverage minimums, make a nicer, more robust meeting for your attendees, pay a little more in the food and beverage, and not have to just waste it on cancellation penalties. There's a lot of strategies there, but that's really your best bet for if you want to cancel your November meeting. I mentioned earlier, if you do move ahead with meetings, August, September, October, November, December, pretty much any time before there's a vaccine for this virus, which is likely going to be, they say, a year from now at the earliest, you are going to have to take precautions in order, obviously, for your attendees and your employees' health and safety, but also to mitigate your liability risk. The CDC already put out, I think it was back in early March, they put out published guidance for large meetings and gatherings of things that you should do coronavirus related in order to help protect folks. I presume that once the in-person meetings kind of get really back online, the CDC is likely going to revise and expand that guidance, make it more detailed and more robust. You're going to want to follow that guidance at a minimum. It's going to be essentially a benchmark for negligence. If you don't follow those things at a minimum, someone could easily argue that if they contract the virus, that you or the hotel or both were negligent in how you carried on the meeting. I'm not suggesting that that's all that you need to do, but you need to look to guidance like that, at a bare minimum as kind of a standard of care for how you're going to need to carry yourselves at this meeting. And it may involve requirements on social distancing and policing it. Certainly is going to involve a lot of cleanliness issues. It may involve face masks. It may involve all sorts of warnings to people. It may involve having medical staff on the standby. And there's a lot of different things that you may need to do. But as we get closer to people starting to hold these meetings, this is something you're going to have to focus on. Do you recommend trying to negotiate contracts for 21-22? I'm talking about 2021, 2022. Try to reduce the attrition clauses. Look, one thing I have seen is that it's a buyer's market right now when it comes to association meetings and events, because the hotels, the convention centers, the meeting venues, the meeting vendors, they're desperate for business right now. They are struggling. And so that's why they're playing hardball on a lot of these cancellation discussions, debates, negotiations. But it's also why they're being, not all of them, but on average, being fairly accommodating if you are willing to hold new meetings. And I've had some great success in getting some fairly favorable contracts for 2021, 2022, 2023. Are we getting them to eliminate cancellation penalties or eliminate attrition penalties? No, I have not. What I have seen is that if you're willing to still hold a meeting this year, then you have a very good shot of eliminating those sorts of things. But for meetings next year and beyond, I haven't seen that sort of success. Can you give me an example of how to tie the force majeure clause into the attrition clause? Yeah, I mean, one way to do it, and I think actually, yeah, if you look in the model provision that's in the PowerPoint that I gave you guys, the last sentence of that provision says, essentially, if this force majeure provision applies, then if we go ahead with a meeting, if the association goes ahead with a meeting, there will be no attrition penalties. That's one way to do it. You could also have, the attrition penalties will apply, but only at 50%, or, there's a lot of different ways that you could do that. Yes, Wendy, I see your question. I will stay on and try to answer as many questions as I can. Have you seen success having sizable deposits returned? So this is a great question. And there's actually, I didn't have time to cover all this, but in the PowerPoint, I have a bullet point that says, possession is 9/10 of the law. That old adage, matter of fact, I have a client call with an association coming up this afternoon where they actually have really favorable force majeure language, really favorable in their hotel contracts for this event. And in fact, there's a stay-at-home order in place in that particular state that's going to cover their event dates in May, which is great. I mean, it's a no-brainer, one of these easy, you don't even need to consult with me. It's such a no-brainer force majeure cancellation for the hotel contracts. But the convention center contract says that if a force majeure event occurs, then the association doesn't have to hold the event if it agrees to reschedule the event for some time in the next 12 months. So that's an example of this is a convention center contract. It's a very convention center friendly contract, very non-friendly to the association force majeure clause. But I've actually seen some that only allow the event venue to get out of force majeure, not the association. Again, those are not the kind of provisions you're hoping for. But in this particular one, because it requires rescheduling in the next 12 months, and because the entire fee to the convention center has already been paid as a deposit, that makes it a lot more difficult. And I'm going to probably have to advise them that unless they're willing to give up the deposit, and it's fairly sizable because it's the full amount, they just recently had to pay like the balance maybe 2 months ago or so. Unless they want to give up the deposit, they're going to have to rebook another meeting with the convention center within 12 months, or everything's negotiable. They might allow it to occur in the next 24 months or something like that if this event is already spoken for next year. But still, you're going to have to negotiate. Whereas if they didn't have a deposit, the association might say, look, we're going to take our chances on force majeure. If they want to come after us, they can, but the burden is on them to pursue us, as opposed to if they have your deposit, you can almost be guaranteed that unless your force majeure argument is very strong, they are going to argue that that deposit is theirs and they're going to apply it toward your cancellation fees. Is that the case across the board? No. We've had a lot of clients get their deposits returned. Because remember, a lot of these are long-standing relationships between the hotel and the association, and the hotels are not being short-sighted. I mean, they're thinking about future business and relationships and everything else. So I'm not suggesting if they have the deposit, you're automatically going to lose it, but it definitely changes the analysis and the calculations. For event cancellation insurance, is the timing of giving notice as important as force majeure? Absolutely, it's just as important, and in fact, because of the way, I didn't have time to really get into this, but the way that these event cancellation insurance policies are written, it's essentially the same analysis. It's essentially an illegal or impossible standard, because most of them are written in the insuring clause or the definition of cancellation in such a way as it says you can cancel if the association is unable to hold the event, or one of the policies, HCC, says physically or legally unable to hold the event. And what they do, the insurance carriers, the same way as the hotels and convention centers, they look at what are the facts that exist at the moment you gave the cancellation notice. And I've heard that the big insurance carriers have their own kind of spreadsheets of all the different states and localities and what sort of governmental bans are in place. And so effectively, it's the same analysis. And so the timing is absolutely critical. For a rebooking, I'm now thinking we should start with a new contract, even though they've offered the same terms and no penalties. And we should strengthen our language. Do you agree? I cannot answer that in the abstract. I will say maybe it's a typical lawyerly answer, but it depends, and it really does depend. I've had some where the language, like the force majeure language and other provisions of the contract, remember, force majeure is not the only important provision here. There's lots of other important provisions. There's the amount of fees that you pay. There's a million other things that are more or less important depending on your circumstances. Room rates for attendees, how much food and beverage costs, attrition penalties, all the rest. And so in those sort of situations, if it's a pretty favorable contract already, then simply doing a one-page amendment, and I've reviewed many of these, is probably in your best interest to do. If, on the other hand, I've given you some examples of some really bad contract provisions from the association's perspective. In those situations, if you have an opportunity to negotiate a brand new contract, you're probably better off doing so, especially if everything's on the table in terms of, from a business perspective, all the business terms and conditions, not just the legal ones. It may very much be in your best interest. So it's really going to depend on each circumstance. And then finally, one of the interesting things I've seen in some of the new force majeure clauses that are coming out from some of the hotels, I mentioned Fairmont, I've seen some from the Marriott properties. They're actually, in terms of the qualifying events, they're actually including CDC guidance and advisories, not just bans like state and local bans or international travel bans, but actually CDC advisories and other governmental advisories that reach a certain threshold. That's good. That's helpful language. Okay. But this is my last point, and I'm going to wrap this up. Even if it says that, don't get all excited and say, oh, this is a great provision because it has all of this, good stuff about CDC advisories. We're not just limited to a governmental ban. Because remember, it's a two-part test generally, the way most of these are written. And each one of those that I've seen still says that makes it impossible or illegal for you to hold your event. And so while it helps, I think it helps strengthen the argument. It really, I think, only moves the needle very slightly because you still have to show impossibility or illegality, which is a very high standard. So even if you see that from a hotel or convention center, you really want to push hard to get one word added, like inadvisable or impractical or commercially impractical, in addition to illegal or impossible. It'll greatly, greatly strengthen your hand in the event that you have to pull the trigger on force majeure cancellation. Thank you for the comments on the plans. Wendy, I'm going to wrap it up here. You guys have my contact information on the last slide, so if anyone has follow-up questions, feel free to reach out. Probably by email is easiest. Thank you all for participating today. Hope you found it helpful, and I'll turn it back over to Wendy to close us out.
Again, Jeff, thank you so much. I know that certainly the SAE members who joined us today took a lot of notes. And of course, as we mentioned earlier, we've recorded this presentation. It'll be ready within probably about 48 hours. We may need to do a little editing on it. We'll send out Jeff's PowerPoint as well as those resources again. And Jeff, again, just terrific, terrific news. Thank you so much for sharing your expertise and your knowledge with the SAE community. We really appreciate it.
My pleasure.
I hope everybody has a great afternoon. Thanks, guys.